Good day. Welcome again to Basic Philippine Law and Jurisprudence, to the series of lectures on persons and family relations. Okay, so our topic for today is a basic introduction on the different kinds of marriage settlements that would govern the property relations of the spouses. Article 74 teaches us that the property relations between the spouses shall be governed in the following order. First, by the marriage settlements executed before the marriage, which can be conjugal partnership of gains, separation of property, or a combination of both regimes. Uh, It can also be absolute community, although absolute community of property is the default property regime, meaning if the spouses did not agree on any marriage settlement before they got married, the default property relations that would automatically govern their property relationship during the union would be absolute community of property. Okay. Second, it is also governed by the provisions of the code, meaning the family code, as well as by the local custom. Okay. Article 75 tells us of the different kinds of property regimes, okay, or marriage settlements. I mean, the future spouses may agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime, because you can actually make a combination of the different property regimes. So parang mixed absolute as well as conjugal, mixed conjugal as well as separate, or a combination of all the property regime. Okay? However, once you have agreed on a marriage settlement before you get married, okay, you can no longer modify the property regime. For example, okay, if for example you are governed by the absolute community and later on you wanted to change to conjugal, okay, and you already got married, you cannot do that. Okay, because in order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage. So once you have already entered into a property regime before you got married, okay, and once the marriage ceremonies is already over, you can no longer modify the property regime that you have agreed upon. Okay? Except, of course, if you wanted complete separation of property, either voluntary or involuntary, which we will discuss later. Okay? The marriage settlements, Article 77, and any modification shall be in writing, signed by the parties, and executed before the celebration of the marriage. They will not prejudice third persons unless they are registered in the local civil registry where the marriage contract is recorded, as well as in the proper registries of property. So Article 77 tells us of the formal requirements of a marriage settlement. Okay? It must be in writing. It need not be in a public instrument, but it is required that it is in writing, signed by the parties, and you must execute it before you get married. Why? Because in order to protect the spouses, protect the weaker spouse, okay, from the stronger spouse. Okay? Article 79 tells us that if one of the parties is suffering from impediment in the giving of consent, such as civil interdiction or any other disability, there is a need for the assistance of a guardian before you enter into any marriage settlement. Okay. Now, The property relations of the spouses shall be governed by Philippine laws, regardless of the place of celebration of the marriage as well as their residence. However, this will not apply where both spouses are aliens. Why? Because of the nationality principle. So the Philippine laws will only apply to marriage settlements entered into by Filipino spouses. But where both spouses are aliens, then the marriage settlement, the provisions of the family code on marriage settlements will not apply to them. Okay. Second, with respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located. Why? Because of the Lex Loci Celebrationis Rule. Okay? The law of the place where the contract was entered into and the law of the place where the property is situated. Okay, and third, with respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for their extrinsic validity. Okay? Article 81 tells us that everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses, shall be rendered void if the marriage does not take place. So just like donations, propter nuptias, an agreement on marriage settlement, the prime consideration of which is the marriage. So if the marriage does not take place, the contract regarding marriage settlement will also become void. Okay? What is a marriage settlement? It is a contract entered into by the future spouses fixing the matrimonial property regime that should govern during the existence of the marriage. Okay, remember when we were just starting uh, the family code? Okay, we said that marriage is governed by law and its terms and conditions cannot be agreed upon by the parties, but because it is governed by law. This is the only aspect of marriage, okay, that the parties can freely agree upon before they get married. Okay? Because they refer to property relations. What property relations would govern, okay, during the time when they are already married? You can do so by entering into a marriage settlement before you get married. Okay? It is a contract, so it must not be contrary to law, morals, good customs, public order, and public policy. What again are the requisites for a marriage settlement? It must be made before the marriage, must not contain provisions which are contrary to law, morals, customs, public order, and policy, must confine itself only to property relation, and must be in writing. Okay? The cases that are to follow is a sampling of all the cases involving the different property relations, from absolute community to conjugal partnership to complete separation of property. We have the case of Nobleza versus Nuega. We have this case is about spouses who even before they got married was able to buy a property. Okay, and then a few years after the marriage, the spouses, the relationship of the spouses turned sour. Okay, so one of these spouses was able to register the said property only in his name. Okay, and he was able also to sell the same without the consent of the other spouse. So is the sale which was made by one of the spouses without the consent of the other spouse considered as valid. Okay, their property relationship is governed by the absolute community property regime. Okay, so what did the Supreme Court say? Rogelio sold the subject property to petitioner without Shirley's consent. Clearly, the house and lot jointly acquired by the parties prior to their marriage forms part of their community property regime. Okay, Shirley proved her financial contribution for the purchase of the house and lot, having established the fact of her husband's guilt in contracting a subsequent marriage. Shirley alone should be entitled to the net profits earned by the absolute community. When a couple enters into a regime of absolute community, the husband and the wife becomes joint owners of all the properties of the marriage. That common mass is divided between the spouses or their respective heirs equally or in the proportion the parties have established, irrespective of the value each one may have originally owned. So regardless of their contribution to its acquisition before their marriage, and despite the fact that only Rogelio's name appears in the title as owner, the property is owned jointly by the spouses. The consent of both the husband and the wife is required, and the absence of consent of one renders the entire sale void, including the portion of the property pertaining to Rogelio, who contracted the sale with the defendant. Okay? We have the case of Pana versus Juanite. This is a case involving conjugal partnership of gains. So it involves a property which is being levied, a conjugal property, okay, which is being levied because one of the spouses was found guilty of a crime and was ordered to pay civil indemnities to the victim's heirs. So Ephraim was acquitted while Melesha was convicted and was ordered to pay damages. Now, can you levy on one of the conjugal property assets, okay, for a judgment of damages on a criminal case committed by one of the spouses? Okay, they insist that it was the system of absolute community that applied to Ephraim and Melesha because of the retroactive effect of Article 256 of the Family Code. Article 256 does not intend to reach back and automatically convert into absolute community all conjugal partnerships that existed before 1988, excepting only those with prenuptial agreements. Okay, so in this case, post-marriage modifications of such settlements can take place only where the absolute community or conjugal partnership was dissolved and liquidated upon a decree of legal separation. The spouses who were legally separated reconciled and agreed to revive their former property regime, and judicial separation of property had been had on the ground that the spouse abandons the other without just cause, and there was a judicial separation of property, or the spouses jointly filed a petition for the voluntary dissolution of their absolute community or conjugal partnership of two. Now, none of these circumstances exist. So their civil indemnity of the decision in the murder case may be enforced against their conjugal assets. Okay? Kiao versus Kiao. So in this case, Rita filed a complaint for legal separation against Brigido. So the judgment was rendered granting the legal separation. Okay, and stating that the share of the petitioner being the guilty party in the net profits of the conjugal partnership is forfeited in favor of their common children. Now, what governs the property relations of the petitioner and the respondent is conjugal partnership of gains. So was his vested right over half of the common properties of the conjugal partnership violated when the trial court forfeited them in favor of his children because he was the guilty spouse. So the concept of vested right is a consequence of the constitutional guarantee of due process that expresses a present fixed interest which in right reason and natural justice is protected against arbitrary state action. From the foregoing, the petitioner's claim of a vested right has no basis, considering that even under Article 176 of the Civil Code, his share of the conjugal partnership profits may be forfeited if he is the guilty party in a legal separation. Prior to the liquidation of the conjugal partnership, the interest of each spouse in the conjugal assets is inchoate, a mere expectancy. Thus, the right of the husband or wife to one half of the conjugal assets does not vest until after the dissolution and liquidation of the conjugal partnership or after the dissolution of the marriage. Because before liquidation, you do not know if there will be net profits. For all you know, there can be a net deficit, not a net profit. So before the liquidation of the conjugal partnership, the share of the spouses to the same is inchoate, meaning it is still subject to the outcome of the liquidation. If there will be a surplus or a net profit and not a net deficit. Okay? Buenaventura versus Court of Appeals. What about those marriages that were declared void ab initio? Okay? What is the property regime that governed marriages that were subsequently declared void ab initio? So it would depend. It may be governed by Article 147 if the parties are not suffering um, from any of the legal infirmities that will prevent them from entering into a valid marriage, or 148 if they are suffering from the state. So, in case a marriage is declared void ab initio, the property regime applicable and to be liquidated, partitioned, and distributed is that of equal co-ownership. So, the liquidation, partition, and distribution of the properties owned in common should should be sustained, but on the basis of co-ownership and not the regime of conjugal partnership of gains. We have the case of Homeowner Savings and Loan Association versus Dilo. Okay, so during the marriage, the spouses, Dilo, purchased a house and lot. The deed of absolute sale, however, was executed only in favor of the husband. However, Marcelino mortgaged the property without the consent of his wife. Um, the loan, however, was not paid, therefore, the property was foreclosed. Okay, in the absence of a marriage settlement, the system of relative community or conjugal partnership of gains govern the property relation. The rules on co-ownership do not even apply to the property relations of the respondent. The regime of conjugal partnership of gains is a special type of partnership where the spouses place in a common fund the proceeds, products, fruits, and income from their separate properties and those acquired by either or both spouses through their efforts or by chance. The conjugal partnership shall be governed by the rules on contract of partnership in all that is not in conflict with what is expressly determined in the chapter. Thus, the property relations of respondent and her late husband shall be governed by the chapter on conjugal partnership of gains and suppletorily by the rules of partnership under the Civil Code. So by express provision of Article 124 of the Family Code, In the absence of court authority or written consent of the other spouse, any disposition or encumbrance of the conjugal property shall be void. The burden of proof that the debt was contracted for the benefit of the conjugal partnership lies with the creditor or party litigant claiming as such. So you must establish that even if the loan was obtained only by one of the spouses without the consent of the other spouse, if the proceeds of the loan benefited the family, then you can hold the conjugal partnership liable for the payment of such debt. However, in this case, other than the petitioner's allegation, there is nothing from the records of the case to compel a finding that indeed the loan obtained by Marcelino redounded to the benefit of the family. So it is the burden of the creditor to prove that the loan went to benefit. The proceeds of the loan went to the family of the debtor. Okay. We have the case of Carino versus Carino. So in this case, we have a police officer who contracted two marriages. Okay. The first one was with Nick Dow and the other one was with Lee. Okay. Petitioner filed claims for monetary benefits and financial assistance from various government agencies. The marriage with Nick Dow was without a valid marriage license, but there was no judicial declaration that was filed in order to void the same. On the other hand, the marriage with G was a bigamous marriage. So what property relationship governed the spouses in both marriages? Under Article 148 of the Family Code, which refers to property regimes of bigamous marriages, the properties acquired by the parties through their actual joint contribution shall belong to the co-ownership. Okay? Considering that the marriage of he and the deceased is a bigamous marriage, having been solemnized during the subsistence of a previous marriage, then presumed valid, the their property relationship would be governed by Article 148. Unless he presents proof to the contrary, it could not be said that she contributed money, property, or industry in the acquisition of these monetary benefits. They are not owned in common by the respondent and the deceased, but belong to the deceased alone, and the respondent has no right to claim the same. By intestate succession, the said death benefits shall pass to his legal heirs. And the respondent, not being the legal wife of the deceased, is not one of them. However, with respect to the property relationship of the deceased Carino with Susan Nicdao, okay, Article 147 of the Family Code governs. Because this article applies to unions of parties who are legally capacitated and not barred by any impediment to contract marriage, but whose marriage is nonetheless void for other reasons, like the absence of a marriage license. Okay, so in contrast to Article 148, wages and salaries earned by either party during the cohabitation shall be owned by the parties in equal shares and will be divided equally between them, even if only one party earned the wages and the other did not contribute thereto. So Article 147 creates co-ownership, entitling the petitioner to share one half thereof. And the other half pertaining to the deceased shall pass by intestate succession to his legal heirs, namely his children with Susan Nicdao. Okay, so that's it for property relations of the spouses. Thank you for listening.